Good day and welcome to the Labor Relations and Employee Rights chapter. Our text begins with the definition of labor union, which is an organized association of workers, often in a trade or profession, formed to protect and further their rights and interests. The text also defines labor relations as the relationship between the management of an organization and its workforce. Now let's take a look at the historical perspective of labor unions. The first unions in the U.S. were craft workers, and they emerged in the 19th century. Many of the workers were working very long hours with poor working conditions and little pay. The newly formed unions fought for better wages, working conditions, and employee rights. With the passing of the National Labor Relations Act in 1935, employees were legally entitled to join the union. It also required management to bargain collectively with union leadership. Union membership continued to grow in the early 20th century, with the highest percentage being 34.8% of the U.S. workforce, and that was in 1954. Today, more than half of Americans hold a favorable view of unions. However, the figure found in our text shows that union membership has continued to decline since before 1983, when the Bureau of Labor Statistics started tracking membership. In 2022, there was 10.1% of the U.S. workforce in unions. Our text explains many government regulations of labor relations found in the following: the Railway Labor Act of 1926, the Norris-LaGuardia Act of 1932, the Labor Management Relations Act of 1947, and there are many more found in our text. A bargaining unit is a group of employees represented or seeking representation by a union. The National Labor Relations Board monitors the process of organizing a union. Once the union is recognized, the next step is to start negotiating with management. The results of those negotiations are what is called a collective bargaining agreement, which includes terms and conditions of employment, such as pay, hours of work, promotion, grievance, and other terms of employment. A grievance is a claim by an employee or the union that the employer is not complying with the terms of the collective bargaining agreement. The grievance follows specific steps to settle the disagreement, and our text spells those steps out. Right to work is a legal doctrine that guarantees no one can be forced to join the union or forced to pay union dues. Another important term in our text is wrongful discharge. That is when an employee is illegally terminated. The definition of discipline refers to methods used to correct the behavior of employees or to help them perform better. Through Weingarten rights, union members are afforded the right to have union representation in disciplinary meetings if they ask for it. Most organizations have progressive discipline to deal with employee issues. These are usually steps such as Step 1, warning, Step 2, written reprimand, Step 3, suspension, Step 4, termination. Remember, progressive discipline is not for those types of zero tolerance infractions. This concludes our review of the Labor Relations and Employee Rights chapter. Have a wonderful day.